too long. I'll keep an eye on attendees, but let's hop into it. So thank you all for joining today. We are here for Mastering Fair Hiring Decision Compliance with Individualized Assessments. We're glad you could be here today. We'll be here for about an hour going over some compliance-related topics. So let me click this. As we dive in, I'm sure most of you here know who we are, but if you don't already, we are CIChecked. We were founded in 2004, and we're a certified women-owned licensed private investigative agency that specializes in pre-employment background checks. So we've been doing this for just over 20 years now, and we had that validated last year with our HRO Today Baker's Dozen ranking. So for those of you who are on the call that helped us last year and are helping us this year, thank you very much. We hope to get it again, but that's a big deal for us in this industry. Quick introductions before we dive in. Person who has been talking to you this whole time is my name's Alex. I am the Marketing Communications Coordinator here at CI. I hit my 4-year anniversary just a couple of weeks ago, actually, in the marketing department, and I specialize in turning hiring complexity into practical guidance. So thank you all for being here again. Nice to meet you. I will pass it over to my co-host here to introduce herself. So Michelle, please.
Thanks, Alex. And thanks everybody for hopping on today. I'm excited about this topic we're going to talk about that has really been around for us and our clients since about 2012, and we'll give you the history about that. But I have over 30 years in the background screening industry. CIChecked is over 21 years old, and prior to that I worked for a couple of other organizations and also been innovative in the industry with data and technology.
Thanks, Michelle. So what are we here to talk about today? We're here to talk about fair hiring decisions and how to make them, how to make legally defensible hiring decisions, right? So we're going to talk about what to do when perfect interviews meet adverse background check results and the situations you might find yourself in. We'll touch on the legal requirements for why you have to do an assessment in the first place at all. And then we'll demo, like Michelle said, we'll demo our individualized assessment decision matrix, which is a tool created internally by CI for our clients to help make those consistent, defensible decisions that you can look back on for future use and all that good stuff. So we'll go through all that line by line, and we'll use a real case study with the names protected for the innocent, obviously, but you can see how we would use it here and how you can adapt it to your own hiring process in your own workplace. We should leave about 10 minutes for Q&A at the end. So if you have any questions, feel free to just throw them in chat or message me directly when you think of them, or save it till the end, and then we'll get to it there. If we don't get to it during the presentation, we will email you after. Sound good? Okay. Before we get into it, I know I'm an annoying marketer, but I do have a couple of polls for everybody. I'm not going to blast you with a bunch of information after. I just want to know this is really my personal, professional use of what people are looking for in that content they consume. So I'm going to launch this first poll, and I'm going to ask, when you discover adverse information in your background check, what's your current process at your organization? Like, do you have a formal assessment process already? Do you do kind of a case-by-case, more informal, maybe Gmail or Teams or like in-person meeting? Or do you automatically disqualify them, or are you not sure, and then you're here because you need a little bit more guidance? And again, you don't have to answer, but it would help out if you did. And again, it's all confidential. I don't see who answers. You're not incriminating yourself by any means. Feel free to answer without a problem. We got more people hopping in here. So I'll leave it open for just 10 more seconds. I think we have a winner. So it looks like most of us are doing a case-by-case review, but some of us have an assessment process, which is great. So we'll go over, exactly how to kind of supercharge that process and what certain states are looking for specifically for what you have to grade. And we'll get into that a little bit later as we move on. So I want to start, everybody here, I want you to imagine that you have the great honor of being hired by Michelle Pyan here as the hiring manager for CI, right? Okay. So you get to place people in our office now. And you're hiring for a verification specialist position. Okay, so those are the people that call employers or schools or references and verify the information on a resume. And somebody walks in, his name is Due Diligence, okay, D-U-E, Due Diligence. He's dressed in a nice suit, he speaks well, he asks good questions, he has a strong resume, has relevant experience. you and whoever you put on your team are like, yep, this is great. We're going to offer a conditional job offer here, pending the background check. But we wouldn't be here if the background check was clean, right? So Michelle, would you mind giving a little bit of a teaser of what we're going to see as we walk through this presentation later?
Sure, Alex. So we've got Dew ended up being convicted of a sexual abuse crime 5 years prior. Dew did not disclose that during the interview process. We'll talk about disclosure and non-disclosure. And our dilemma is how to make a fair, legally defensible decision, whatever our decision might be.
And this case really matters because there's a verification gap of interviews versus resumes. They don't necessarily tell you everything. As we heard in the example here, candidates don't always volunteer adverse information. You can't necessarily have a policy that says any criminal record equals no hire. So every adverse action does need to be defensible, and we'll talk about that in just a second here. But I do have another quick poll because I think I have 4 questions total, but I got to get this one out there quickly here so I can stop sharing that. Go back. We can launch this one. So I'm going to ask, which compliance area is the biggest concern for you when making hiring decisions? Is it the EEOC, discrimination claims? Is it FCRA, procedural violations, state-by-state requirements, or maybe inconsistent decisions between managers that you might have? Okay. Okay. Interesting. We'll leave it up 5 more seconds. Oh, nice. Last one at the buzzer there. Okay, share results. So we got a good spread here. So 2, 2, and 2 for EEOC and FCRA, and then another one for the inconsistent decision making. So this will be great. We'll document all of these things in this tool, and you'll see exactly how here in just a second. Stop sharing this, and we'll go back here. So Michelle, Dew's case raises a lot of compliance questions that we'll get into. But why exactly do employers have to run individualized assessments in certain states to defend their hiring decisions? Could you go through that with us, please?
Sure. So it's good practice from a number of perspectives. There's a number of things that come into play that you just covered in your poll, and our audience is well versed with. You've got the Fair Credit Reporting Act, and that's kind of a how, and then you've got the EEOC, which is kind of the why. So some guidelines there. With the Fair Credit Reporting Act, it's an actual law, where the EEOC is actually guidance. So it's strongly recommended, and it has an administrative process behind it. The Fair Credit Reporting Act applies to companies like ours that are consumer reporting agencies, and then organizations like those that our attendees are a part of, which are usually employers, maybe a volunteer organization with volunteers, which does fall under the employer definition of the Fair Credit Reporting Act. So this particular slide has a lot of information, a lot of good take-home stuff. You will be getting access to these slides and other information after this from Alex. So that'll provide some good insight. And then there's other things that were part of your poll as well that we're going to get into a little bit, like the state requirements.
Absolutely. So if we were hiring in New York State, Michelle, what are some New York State ones that we would have to be cognizant of?
Sure. So the most recent one is New York Clean Slate, and we've got a lot of information out there about that. So that does come into play, and it does have some considerations around it. We've also been through a series of New York Ban the Box at various jurisdictions. So it's not statewide, and sometimes it's only public employers, not private employers. But those of you have been faced with a number of these or heard of them. And then if you're operating out of New York City, you've got the Fair Chance Act. So a lot of things that come into play there.
And we do have, you see that link there at the bottom if you want a little bit more information on kind of a wide overview of New York State hiring compliance. We did write a little compliance guide based on a number of different rules and regulations that New York State has. So that's linked there in the slides, and you'll get that after. There is, Article 23-A as well that we didn't mention here that we'll go through before we get through the example, because that directly applies to the individualized assessment process, and that kind of fully outlines it. So these are good to keep in mind. They don't necessarily apply directly to this process, but they will come in play during your hiring process in general. So, Michelle, we've established that do needs an individualized assessment. But before we jump right in, we've seen, you and I have seen, that a lot of, not necessarily a lot, but some employers make some blanket policies that can, put you in a little bit of legal liability. So would you mind going through, before we dive in fully, some of the more common ones that we see and why, employers need to be careful about how they structure that policy?
Sure, sure. So I can imagine the audience kind of shivering in their seats right here. But we do hear these even today. People like to have automatic disqualifications. They just find that it's really easy for their job. And I can understand that. We can all understand that. But these laws don't lend themselves towards being that easy, of course. We're in, a lot of us are in New York and we're dealing with HR, so it's not easy. Um, there should never be anything automatic disqualification unless there's a statutory significance behind it where specifically somebody say needs to be fingerprinted for a job and it's if this then that, very black and white and very regulated and very much backed by statutes. But some of the things we hear, well, any felony conviction is going to be automatic disqualification. Well, that's right up front illegal under the EEOC guidelines, or a violation of the guidelines, seeing that's not actually a statute. Well, we don't want any criminal history within the last 10 years. That's time frame bound, but not job relevance bound. So it's not a great, it's not even an assessment, but it's not a great policy either. Anything theft related offense for any position, we're just not going to deal with that. No drug convictions. That one you got to really be careful with, especially with marijuana being legal in a lot of states. And then we've got, any violent crime. So, these in and of itself, because these are bad policies, it doesn't mean that you don't hire or that you do hire somebody because you want to avoid these policies. It means you do an individualized assessment that we're going to get into here and that some of you are familiar with, or you're doing a case by case right now, maybe have different ways to document things than the way we're going to show you and everything like that. So you want to avoid these dangerous policies. You don't want them to be policies, but it's very likely at the end of the day, when you've been using, say, our tool, the individualized assessment decision matrix, I realize it's a mouthful, but it's very descriptive what it is. So if you use a tool like that, you actually have documentation over a period of time of what decisions you've made anytime there's been adverse information in a report. So that may lend itself towards where, you didn't hire anybody with a felony conviction. Nobody you hired had a crime in the last 10 years. Oh, nobody you hired had a theft related crime, and there was no illegal drug conviction on the books for anybody that you hired, and anybody with a violent crime didn't end up getting hired. So certainly this can all happen, but it needs to happen by way of an individualized assessment and proper documentation, not by the way of having a blanket policy. I'm sure you've all sat and cringed in a meeting where a hiring manager or even an executive or somebody says, well, we don't want anybody hired with a felony working here. And you're like, yes, but, and then you've got to make sure that everything supports everything in a legal way. That's what we're here for today, is to help you support that. As you continue, you will always continue to combat types of comments because they don't realize that could imply there's a policy. There's not a policy, and you're going to do everything you can to show there's not a policy. There might be a mindset, but you're going to have documentation to support the decisions made by using an individualized assessment.
I couldn't have said anything better myself there, Michelle. That was great. Skipped over here. Skipped a little bit. Oh my goodness gracious. Hold on a second. Hold on, folks.
Settle down, Alex.
Hold on, folks. Sorry about that. I tried to go back and it didn't let me go back. Okay. So, Michelle, can you explain? You kind of already did, but can we go over just so everybody understands why these policies fail for these guidelines specifically, you know, for the couple of reasons that you talked about here.
Sure, sure. So, they just open you up for vulnerability, liability. There's inconsistencies, so they could be framed as discriminatory. Those of you in New York State know that under, I believe it's the human rights law, where there's protection for people convicted of crimes. That's part of the reason why Article 23A exists and other things. So right off the face, it can be discriminatory. There's a business impact. Let's step back, and I know we're not here to talk about clean slate, and we did mention it, and we mentioned ban the box in the New York City Fair Chance Act, but are you eliminating qualified candidates unnecessarily? Is it really the right process for your organization today? And that's part of the reason some of this should be assessed regularly. Are there compliance gaps with these? We saw those were blanket policies. Those were not compliance procedures, compliance tools like we're talking about here today. And then, with Du's example, it's pretty easy to say no sexual offenses, but you still need to defend that. So you still need to go through the process, and you still need to avoid any liability created by the inability to have proper documentation for it, and strong documentation for it.
Perfect. Thank you. So let's go back to when I had everybody imagine that you worked for CI, right? Let's go back to that, and let's take an example, or that you work in New York. I know most of you in here probably do, but if you don't, imagine you work in New York. New York has a special Article 23-A that kind of outlines exactly what employers need to grade on based on what they laid out there. So Michelle, would you mind going through the 7 factors, call them factors, of Article 23-A that are important for employers during this assessment process?
Sure, Alex. So it's a multi-factor situation going into play here. Now, it's extremely similar to the EEOC guidelines, or I should say the EEOC guidelines are very similar to Article 23A. The EEOC guidelines came into fruition, I believe, around 2012. Article 23A dates back to, I believe, 1978. Okay, so New York, once again, way ahead of everything. But very similar in the multi-factor situation of what needs to be considered on a, say, you said case-by-case basis was in your poll, and a number of you said that, or an individualized assessment, which is another term for a similar type of situation, just maybe a little bit more formalized. So with Article 23A, we've got the nature and seriousness of the offense. We have the time lapsed since the conviction or completion of the sentence, and we could talk a little bit more about that. Actually, we're going to talk more in depth about all of these as we actually look at the tool and get into this a little bit more. What was the age of the subject at the time of the offense? What was the evidence of rehabilitation, if any? What job duties and responsibilities are involved? Yes, this is where a good job description comes into play. And I know we all hear about job descriptions on a regular basis. Even me, as somebody running an organization, I've got job descriptions happening with my HR person right now. Employers' legitimate business interest. The law does allow an employer to think about your legitimate business interest. It's not all the best interest of the candidate. It's the best interest of the business as well. And then above and beyond that, we get out into the public safety considerations. So there's a lot that comes into play here, and a lot that needs to be considered. So you can see where a blanket policy like those we had up before just don't come into even touching this type of assessment that needs to happen.
And this isn't necessarily just a New York State thing. There are other states that have, some type of version of 23-A. It's not a national or federal thing, I believe. Michelle, check me there, but there are a number of states that require this, and there might be in the future. So it's always good to know this state by state requirement as well.
Yeah, that's right, Alex. There are some states that do not touch on this, and then you've got the EEOC guidelines. So then you have to decide if you're going to follow the guidelines, or if you're going to open yourself up to liability by not following the guidelines. So there are some background screening companies out there, and some, you can set up your reporting requirements with your background screening companies very specifically to your situation, and you can guide the information that you get. So you need to take all of that into consideration when setting something up.
Absolutely. So now that we know the 7 factors that our hiring or imaginatively hiring managers would have to grade by, can we go through with Stu's information, some information the audience knows, some they don't know yet, but we'll get into in just a minute here.
Yeah, sure. So we're gonna dig into Do, and I know we've introduced this a little bit, but just to go back, so this is a real case with a different name changed. This is a situation where CIChecked was hiring a verification specialist, somebody to be in our office, somebody to actually sit next to their coworkers on a 40-hour-a-week basis to do verifications, to interact with organizations, to verify employment, verify education, get references, things like that. So that was the type of position that we're hiring for. And the candidate's name was Do. We have a resume that we've looked at. We have a background check report, which of course is what your background screening company develops for you. And then we also have the job description. Okay, so a lot of things come into play. We've got all of this we're looking at. Do's background check report came back with a serious offense with what we felt was direct job relevance. It was a sexual abuse conviction, and we're going to dig into it a little bit more, but it actually was a felony level. And there has been 5 years lapse since the conviction of the crime. So, that's a moderate time frame, considering it was a felony. Is that enough time or not? This all requires some type of decision making. Do was 49 at the age of the offense, so a mature adult, this was not a youthful indiscretion. We did not have rehabilitation evidence provided. So had we, when I was listing the documentation, we were looking at the job description, the resume, the report, we would have included rehabilitation paperwork there. We didn't get any of that, and we'll talk a little bit more about what that is in a bit. Again, with verification specialist role requires Do to work with female colleagues. That's important because when we dig into the conviction, the victim of Do's crime was a female. So we have demographics related to around the job and the conviction relating to a female individual over the age of 18. The employer's interest as the employer, we want workplace safety and trust. We want to make sure our employees trust that we're hiring people who are going to work alongside of them, that they can feel comfortable with and not have altercations with. And then the public safety, our organization shares a parking lot with 6 other organizations. So there's a lot of public access, public space, and public safety considerations to be considered in that type of situation. So that's the background about Do's assessment that we're going to jump into with the individualized assessment decision matrix.
Perfect. Thank you, Michelle. So before we get into detail, just to reiterate, this is for, how we can treat similar cases or different cases similarly without creating that liability, and we'll build that precedent for future decision use. So before we dive in, I do have another poll here for us. I'm going to ask, which factor is most challenging to evaluate consistently for you? Is it the time elapsed, the direct relationship to the job, any evidence of rehabilitation, or balancing the employer interest that Michelle mentioned with, all the fair chance compliance requirements that, you have to do usually? Leave it open for a little bit. This one, people might be thinking a little bit more on this one. Not as fast as the other one. Rolling in. I'll give it another 5 seconds. 9. All right, we're done here. So we did have a winner. It was balancing that employer interest that you talked about, Michelle. So I think that one probably makes sense. It's a little bit more nuanced, a little bit more case by case, employer by employer basis. Does that make sense to you?
Sure, yeah. So there's a lot to consider here, and this was a great poll question, Alex. And it is balancing that, and that's where, one of the things here, talking about the consistency principle in treating similar cases differently creates liability. A tool like the individualized assessment decision matrix allows you the ability to look at past decisions, and that's the strength of it, in pulling everything together. There's lots of ways you could document on a case by case basis, but if you don't have a place that you can pull your case by case decisions together into a tool like the individualized assessment decision matrix, you're giving up the opportunity to make sure that you're acting consistently throughout an organization. And we're all really familiar with the fact that there's been a lot of turnover everywhere, and including HR departments. So a decision might have been made 2 years ago that the people making the decision today aren't necessarily aware of, because there wasn't proper documentation to pull all the case-by-case situations together into one large document. So that's one of the things we were talking about here before the poll. And then you're creating every decision you make on adverse information you get in a report, whether it's the decision to hire or the decision not to hire, a decision needs to be made. Every decision creates precedents for future cases like we're talking about here. So it establishes what the organization is going to do going forward. It doesn't mean you can't pivot, but if you have an individual assessment decision matrix tool that pulls every case-by-case analysis together, you can document why a pivot might have been good at a certain point in time, and why you might have gone and made a decision differently than you previously did. If you don't document that and discovery happens in a case and it's discovered, then it isn't as impactful in a positive light on an employer than an employer who's proactive in a situation like this.
Absolutely. Absolutely. Well said. Well said. So I've teased it long enough. We're about halfway through here now. We'll go through kind of the individualized assessment decision matrix. It is a mouthful. We call it the IADM as well. So if that's a little easier for you, feel free, IADM. So we know why we need these assessments. You did a great job explaining, the federal regulations down to the state, down to the minuscule of why exactly we need to do this. Let's go through it. Let's start. We got the report back. How do we start filling out this tool line by line? Would you take us through?
Sure, great. So just so anybody knows, if you've got any questions, please type them in. We will be doing a bunch of questions later on and getting into some of this. I know that this can be pretty involved, so we've set the baseline of why, as Alex said here. Now we're going to dig into the tool itself. And once we're done digging into the tool in this particular situation, Alex will show a great video that we did. It's just a short clip of pulling the whole tool together. What we're essentially looking at here is an extremely large spreadsheet. It's got quite a list of instructions and details along there. Now, essentially what this is a few columns documenting some basic information so that we set the stage with some of the things we've been talking about. And it also then gets into the language of Article 23A in New York, and it gets into the language of the EEOC guidelines. So as we go through here, you might be like, oh, that's a little duplicative, or that sounds like that sounds like that. And that's by design with this tool. Should you have an audit by the New York State Department of Labor, they're going to be looking for that Article 23A language. Should you have an audit at a different level where an individual is, say, representing a federal agency, or the EEOC itself is coming in, they're going to be looking for their language. So instead of muddying it or trying to make the decision that we're going to reword it, we used a lot of the verbiage exactly from the Article 23A statutes and the EEOC guidelines. So this big tool brings all of that together, and it protects you from all of these different angles and all of these different potential organizations that could look at you as perhaps being discriminatory or liable to an individual because of something that you did. Okay, so laying the groundwork there. One of the things you want to document is you want to be able to track this back to your background check report. Now, this tool can be used by a number of different people. Let's say ourselves, we're the people that we have to document this tool every time adverse information comes up in a background check report. Okay. Now, this tool may be looked at by legal, it may be looked at by the EEOC, by New York State Department of Labor, by your chief human resource officer, by a team to make future decisions and stuff like that. You might have adverse assessment done on an individual you hire. So we want to make sure that we're not putting the person's name in here. That's why we don't see due diligence here, but we see a CIware order number. That allows anybody with access to your background screening system. Now, whether you're a CI client or not, you should have some unique identifier on every report. That's essentially what's here. We call it an order number. What's your report number? What's your unique identifier in that report that if you went into your background screening software and put it in, it would tell you who the person was. So only those people with that ability to access the system can then go in and revert back and find out who these people are. Okay, so that's done by design for to protect the confidentiality and to protect people that you may hire who have adverse background check reports. Okay, so big explanation about column A. Column B is the date of this analysis. So we did a lot with this tool since 2012 when we developed it. We had a precursor and then the EEOC guidelines came out. And so we developed this larger tool. So yes, this is a 13-year-old tool. But last year we developed substantial documentation to enhance it. The story that we're talking about, the report we're talking about, the resume we're talking about, the job description we're talking about. We pulled all these pieces together to create a more educational experience for our clients, for them to understand this. Okay, so we did this analysis back in 2024, exact date documented there. At that time, what was the age of our subject? Subject is the person the report is on, due diligence. So at that time, due diligence was 54 years old. Okay, so establishing some baseline here. This baseline, especially the age of the subject, can be used when you're looking at your larger decisions and not your case-by-case decisions to determine the precedences that you've previously set within your organization. Okay, then we move on and we've got some sections. These deal with the conviction. Now, you can use this tool and you should use this tool every time you have adverse information. Now, adverse information can be a will not rehire employment verification. It can be a professional license that defaulted. It can be an invalid driver's license. It can be a number of situations that are adverse. Now, depending upon your background screening company, they may bring them all to your attention with, like, say, a red flag or a hand or something saying, maybe it's a color yellow, saying, hey, why don't you take a look at this? So some of that's there. And sometimes you just need to look at the nitty gritty of every single report, which we all know is proper due diligence, so to say. Okay, pun intended. All right, so looking at these columns, what's the type of adverse information? So here we're dealing with criminal. We're dealing with multiple results that came back that were duplicative on the same report. Okay, the first and foremost, due is a registered sex offender on the New York State Sex Offender Registry. Okay, beyond that, in column E, due also had the details of the criminal record come back in a cyber investigation, in a developed criminal record, in cursory indicator, New York as well. So, and the origin report. So all of which indicates that they're all the same case and it's duplicative within your report. But you see that a number of sources that are part of this client, being ourselves, background check report revealed this information. Okay. Then the level of the conviction, misdemeanor or felony. Felony risk level, non-violent, but it's a tier 2 sex offender. There's 3 levels of sex offenders in New York. This is middle of the road. Okay. Now, felony. Now, I'm just going to give you a little, for those of you who want to be criminologists out there. We start with misdemeanors and we go up to felonies. The most serious crime in New York State is a Class A felony. Okay. The least serious crime in New York State is a Class E misdemeanor. Violations are not crimes in New York State. A crime in New York State is a misdemeanor or felony. So you go from a Class E misdemeanor, still a crime, but the least severe, to a Class A felony. Felonies are more serious than misdemeanors, and there's classes within there. So easy to follow there. With the sex offender registry, tier 1 is the least offensive, where tier 3 is the more offensive one. So it's a little bit different for me to grasp, but tier 3 sex offenders are the most severe. Okay, so a little knowledge there. Some more knowledge is every state classifies things a little differently. So just because New York calls something a Class C felony doesn't mean it's not a Class A felony somewhere else. Or a good example is New York State has a lot of misdemeanor classified crimes that actually appear as felonies in other states. So it's interesting there. So you have to really watch that you're like, if you're basing your decisions on a lot of New York criminal information, that you're maybe doing a conversion to other states. And that's easy to do, especially with AI these days. But just searching penal codes and things like that to find out the equivalent crime level, or ask your background screening company, especially if it's CI. Sorry, I couldn't resist. Okay, so then we have the description of the conviction. So every penal code number has a description. In this particular case, we have facilitating sexual abuse with a controlled substance, the victim's information. Generally, you only get the victim's information with a sex offender registry situation, not with a crime. Sometimes it's there, but a lot of times not. And then we have sentenced to 6 months in prison and 5 years probation is our sentence here. So we have some good information that we pull this together, put it all on here, because you're going to want to use this when you're doing a case-by-case situation later on and see how many details match or don't match, so that you can tell if your decisions match or don't match. Okay. Job relevance. So H through L, we've got the job function. So here's where the job description comes into play, and how does the job description relate to that? So we've got some information about working with others in the office as a requirement there. So there's a direct correlation between the crime and the offense sought. Some of these, J and L, or an either or. So J is a yes, so we can skip L because it's an either or situation. But there's also a spot here if it's not a crime to document it there. So that's where you talk about an adverse employment verification, or invalid driver's license and the person's driving. Those are pretty quick and easy, but should be documented because it's adverse information found in a report. Okay. Let's see. Then we've got M through Q. So you can tell how big this spreadsheet is with all these different slides that we created this for this particular presentation. So we've got the job relevance here. So we have a higher level of public policy than a lot of other employers because we are a licensed private investigative agency. So everybody who comes through and works with us has to be able to be licensed as a private investigator in the state. So it's very unlikely that somebody with this level of sexual criminal conviction will be approved by the Department of State to work for a private investigative agency within the state. So we document that in O. Additional information provided. A lot of times what's coming into play there is during the interview, did they indicate anything? Did they indicate that there was a criminal conviction? Did they provide further details that you should be considering here? Generally, that doesn't happen. Our job description specifically says that, they have to act independently, but they have to work with others inside and outside the organization. So they're going to independently be doing verifications, but they're going to be training and working side by side with people, breaking with people, and using the same parking lot as other people in the organization. Any bearing on the criminal offense for which the person was convicted for the fitness or ability, and that's a yes. There's a bearing on this conviction to their fitness to be able to do this position. Moving on, we've got R through V. So here's a time-lapse situation. So Du's conviction happened in 2019, so it's almost 6 years ago. There's a direct relationship to the nature of the job. Yep. And Du was 49, now he's 54 when it happened. So just some further documentation here. Again, this may seem documentation heavy, but it becomes very easy then when you're doing an analysis between situations to determine your precedences and also to defend your organization against any claims of discrimination or liability when any organization comes in or just does an audit. Seriousness, we determine it to be very serious. Our language, you might develop your own little code or key for how you fill these in. It's very encouraged to do that. We were provided no further details, facts, or circumstances surrounding this situation. So that was column V. Okay, so moving on a little bit, we've got some final decision here. Rehabilitation. I think in my 30 plus year career in this industry, I've talked to 2 people who've actually been presented with rehabilitation paperwork. It's extremely rare, especially in New York State. Now you will get it. It will be like some type of hard copy, some type of a legal form, some type of a document provided by the court. Usually it's signed by a judge. That's the reason it's so rare is in New York State, judges are elected. And very few judges are going to sign something declaring somebody's rehabilitation from criminal tendencies and then risk the fact that that person may commit another crime and that have a bearing upon that judge's reelection opportunities. So you see the connection there. So that's why it's very rare, but yet it is possible. And some of that is going to be happening with clean slate now, and that's just kind of automatic because it goes away. So that's kind of a better way to deal with it. Take it off the judge's responsibility. Okay, so
Almost there. We got one last couple of slides here for you, Michelle, of the final decision documentation.
Yep. So we're wrapping it up here. There is an interest for the public and private employers in the safety and welfare of individuals and the general public. We feel that that's very much at case here, and there's an extremely high interest in the subject is not suitable. We also have to consider again here disabilities of certificate of relief from disabilities. That's what the rehabilitation paperwork is usually titled. And we didn't get any of that provided. And was the person excluded because the conviction is job related for the position in question, and thus, so yeah, they could be, it is job related and they could be excluded. So that was our determination here.
Perfect. Thank you. So I think I'm going to ask this question, but I think most people know where we're leaning here on this next slide. The very last cell there, column AE, is did you hire this person or not? So, Michelle, did you end up hiring due diligence? Unfortunately,
we did not.
Yeah,
we did not.
So. Yeah.
And this is just, this is an added column. This is not part of the EEOC guidelines or Article 23A, but you got to document your final decision. So that's the notes column here. And this individual is not hired versus hired. So this is one person through one line of a multi-line, multi-column spreadsheet that we've documented here, and we've done our individualized assessment decision matrix. We've complied with Article 23A, and we've followed all of the EEOC guidelines.
Thank you. So we've walked through it kind of step by step now. We do have, Michelle mentioned that we do have a quick video of kind of so you can see the full tool all at once. It's just short of 2 minutes, and there isn't sound on it. So if somebody wants to do the Jeopardy theme or something while it's going, feel free. But it'll give you a good idea of just how big this tool really is here. So we can watch it here for a second. And you can see it does take a little while to scroll through there. So thanks for dealing with that. But it is just quite that big. You would just go kind of down the line with every report that you have to make a decision on, and add a new row there at the bottom and track that dates and all that kind of good stuff there. So that was essentially what we had for you today for the IADM process. You got to look at the tool, why we're using the tool, why it's important. We are going to open it up for some Q&A now. I did have a couple through the chat message directly to me, but if you have any, feel free to raise your hand or throw them in the chat real quick here. So, excuse me. Michelle, got a question for how do you handle cases where the conviction seems minor, but the candidate was not honest about it? Well, we kind of touched on today, but important to reiterate.
Yeah, that's a great one, Alex. And we did talk about, disclosure versus non-disclosure of the information. And in this particular situation, did not disclose. So he was not honest to begin with. Back in the day, it was very easy to document that lack of honesty and go about your day. And that still remains very powerful. However, you have to look at your background screening situation and find out where are you collecting that information, if at all. I know it's been advisable with a clean slate and other things to eliminate that from the background check process. We do have clients that opt into it, asking, have you been convicted of a crime, and asking for further details, but a lot of clients says, I have opted out. So it's even going away from the fact that knowing if somebody was honest or not in the disclosure about the situation. It's still advisable to use the individualized assessment decision matrix. The more you can document the situations, the better an audit will be for you later on. So even if you document it as much as the first few columns, and then in the notes you put that when asked the criminal conviction question, the individual indicated no, but the conviction came up. They did not dispute that it was them. They did not, do an dispute when sent the pre-adverse information, stuff like that, and you document that there. The more you have documented on a tool like the individualized assessment decision matrix, the easier it's going to be with the Department of Labor. And there's actually a situation where we had a client use this, and they get they're in an industry like, let's say maybe cleaning, and they get a lot of adverse individuals come through. They use this a lot, and they hired individuals with criminal convictions, but it was all documented on a tool like this. So when New York State Department of Labor came in and said, well, it's been claimed that you never hire anybody with a criminal conviction, and that you're violating New York human rights law by not complying with section whatever. Okay. They pull up an individualized assessment decision matrix that has a number of individuals with criminal convictions indicated that they were hired. End of case. It was one of the quickest, easiest ever, and it's probably the foundation for why we continue to promote a tool like this for our clients to use. It just became very easy for them to go against somebody claiming a situation like that. So, honesty has a big bearing upon whether or not any of us want to work with somebody, so it obviously needs to be considered, but you have to think about when in your process the honesty factor can truly be evaluated and how to deal with it there. So what's your thought on that, Alex? Did you have anything more to add?
Well, I think, you still have to do the assessment process either way if they had a conviction, right? So, you still have to relate it to the job relevance and see if it applies there. I agree with most of what you said, but I guess we did have one that kind of relates to this as well. Is if the due situation, if he was honest about it in the interview, would that have changed anything?
It would have changed the documentation on the individualized assessment decision matrix, because there's a section there that asks additional information. So in that section of in that cell, we should have indicated that they didn't indicate a criminal conviction during the interview process. So that would have had bearing on the honesty there. But in the be all end all of it, looking at the other criteria, it would not have changed the not hired decision situation. in this particular case, but it certainly could have in other cases. That's a great question.
That makes sense. Great. We did have one last one of do you have anything or do you have any tips for training hiring managers to use this tool?
Okay, well, I think it's very good for your HR team and your hiring managers to be exposed to something like this. Who fills this out should be you should create some type of key as far as what are the right answers or what are the answer. You can even do a drop down with a multiple choice and stuff because you want to be able to sort on this as it grows. So you want to be careful how many people you have actually documenting stuff in here. I think letting the hiring managers know that this process needs to be gone through and that this could extend, the time to hire or time to send the pre-adverse action notice, that time could change because this type of assessment needs to be done and it's not something to be done on the fly. You really, as you saw, it could take you probably 20 minutes upwards to fill some of these out. Once you do a few of them, it becomes really quick. That's where it's beneficial for an HR person to be doing more of this than a hiring manager. So it's kind of, where do you want to take the tool? Do you want to take it to awareness or do you want to take it to responsibility? I think it's important that hiring managers are aware of this as part of the process in the whole hiring realm.
Perfect. That's great. Thank you very much. I don't think I have any other chats left. Nobody's chatted you specifically, right, Michelle, with a question? I don't think so.
No, I'm not seeing it.
Okay. Well, if nobody else has any other questions, before we wrap up, if you are a client and even if you're on this specific webinar, if you registered, if you go to this website, CIChecked.com/IADM-contact, or if you send us an email, you can get access to this tool with the kind of example in there to help you walk through, and we'll send you over the demo video that we had in there today. So if there are no other questions, feel free to go over there. Oh, go ahead, Michelle.
Oh, sorry. Yeah, Alex is going to send everything out, follow up with any questions or anything. And, we've got a few extra minutes if anybody has just any general questions on background checks or anything like that. We're here for you.
Absolutely. Absolutely. Yeah. Everyone will get the recording, the slides, and your SHRM credit if you attended here in the next week or so. And we'll be blasting that out for everybody who attended. So one last chance. Does anybody else have any questions for myself or Michelle here today? Going once, going twice, going three times. Okay. If you don't, well, we appreciate you again taking the time to be with us today. Hopefully you found it valuable. Hopefully you might use the tool in your own hiring process. Again, if you have any questions, please feel free to call that number or reach out to info@CIChecked.com. We appreciate your time and have a good rest of your day, everybody.
Thanks, everybody.
Yep.
Thank you.
Absolutely. Have a good day.